Thanks for joining us today for Jennifer Schatz and Associates in our Webinar Wednesday program. We're coming to you live from Washington, D.C. Our webinars are every Wednesday and are provided complimentary. They're recorded and can be downloaded from our website and YouTube channel, which now holds over 300 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for our speaker, we will have his information on the last slide of the presentation today. A special thanks to our educational sponsor, the National Veterans Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. And now a little bit about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. We also have opportunities for your organization to advertise in our newsletter. We now reach over 17,000 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. And now to introduce our speaker, Ed Delisle. Welcome, Ed. We're glad to have you here with us today, and I'll turn the floor over to you.
All right, thank you very much. Yes, my name is Ed Delisle. I am the chair of the Government Contracts Practice Group at Kerman. I'm based in suburban Philadelphia. I spent most of my career in downtown Philadelphia and recently moved to our office in Plymouth Meeting, which is just outside the city. We have offices up and down the East Coast. Today, we are going to focus our discussion on bid protests. If you want to advance the slide. What we're going to do today is take sort of a 30,000-foot view of the bid protest process at the federal level. In today's crazy environment with everything that we're dealing with, it's hard sometimes to focus on business as usual, but business is happening, believe it or not, and as we progress through this very challenging time period, we can be assured that government procurements will continue to be protested for one reason or another. In fact, as we speed through and attempt to deal with the challenging environment that we're in, I can assure you that there will be instances where you as a company will feel that you're being treated unfairly in some way, shape, or form as part of the procurement process. So understanding how protests work in the federal sector is going to be important to you. If you can advance the slide. So where do we start? How about the very beginning? So what is a bid protest? Well, a bid protest is your ability to challenge a solicitation or a decision based upon a solicitation to the extent that you feel that you've been treated unfairly in some fashion, or if you feel that a solicitation that's been put out for public consumption by an agency is unfair to you in some way. The most important thing, and the thing that I hope folks come away with this afternoon, is that timing is very important. You need to understand the rules, and in particular, you need to understand the timing that's associated with the rules and regulations that pertain to the protest process. Okay, if we can advance the slide. All right, so who can file? Not everyone can file, only an interested party can file. And an interested party is described a little bit differently, or should be understood a little bit differently depending upon what you're challenging. So on a pre-award basis, where someone would like to challenge the basis for the solicitation itself, verbiage contained in the solicitation, or the manner in which the solicitation is composed, an interested party is a prospective bidder, someone who would otherwise qualify for the service or the product that the government agency is attempting to buy. Pretty easy hurdle to overcome, a prospective bidder. You just simply need to qualify for whatever it is the agency is attempting to buy, whether it be a product or service. So you're a company that could provide that product or that service, but for some error that you see in the solicitation verbiage itself. On a post-award basis, interested party is an offeror who, you have to be an offeror whose direct economic interest would be affected. So in some way, you have to make the argument, we'll get into this in a few moments, that you would be in line for an award, but for the error that took place as part of the bidding process. Okay, if we can advance the slide. So what are your options? Generally speaking, if you're interested in challenging a solicitation or an award, you have three options. You can go directly to the agency that issued the solicitation or award, and if you decide to go there, you file your protest directly with the contracting officer. Option number two is the GAO. You can go to the GAO, which is the most popular place to lodge a protest. And if you opt to go to the GAO, at some point, if the agency doesn't take corrective action, you'll have an attorney with the GAO make a recommendation of some way or in some way, shape, or form. And we'll get into the options that are available to the GAO attorney that's assigned to the case if that's where you decide to go. Your third option is COPSI. It's the United States Court of Federal Claims. That option is very similar to normal court, if you will, or being a part of a more traditional process. You have a judge assigned, and we'll get into some of what that means. Generally speaking, those are your options. What we're not going to cover here today, but it represents a fourth option, is if you desire to challenge the size or the status of a company who is going to receive award on a that's been set aside for a particular group or category. So for example, if an opportunity has been set aside for a service disabled veteran-owned small business, and you are such a business and you wish to challenge the award to that company, you can do that, and you can challenge the status or the size of the awardee by going to the contracting officer with your issue or set of issues, and the contracting officer will then funnel that information to the Small Business Administration for further proceedings. So that's yet another option. As you see here on the slide, the FAA has its own processes and procedures that it uses as part of a separate protest process. So if you have a contract or a potential contract with the FAA, you have a separate set of regulations that you need to adhere to. We're not going to be covering that today. We'll simply be focusing on the three major options that you have, which you see here. Okay, if you can advance the slide. So as I alluded to a few moments ago, you have two types of protests. You have your pre-award protest, which would be a challenge to the terms of the solicitation itself or the bases for the competition that will ultimately result in an award. So if you believe, for example, that a solicitation is too restrictive in nature, you may want to file a protest on a pre-award basis to challenge the selection process. I just had one of these not too long ago involving some work at the Pentagon, and these, in terms of past performance, what was being asked was by in terms of the selection criteria, was that they wanted a contractor who performed a certain amount of projects, let's say 3 projects for that agency at that facility, the specific facility that was at issue, within 3 or 5 years. The problem was there was really only one contractor who could have qualified under that criteria. So based upon that, among other reasons, we filed a pre-award protest. We challenged the terms of the solicitation, and ultimately the agency decided to take corrective action and to address that and other issues as part of what, obtaining the service that they were attempting to obtain through that solicitation. So that's pre-award. Post-award, this is the area where I see the most activity myself, and it's where the vast majority of challenges are made. It's a challenge to an agency's evaluation and or award decision. The thing about post-award protests that are particularly important is to understand, and we'll get into this in a few moments, the discretion that's afforded to an agency as part of the selection process, and thinking about that in terms of your basis to protest and the ability to succeed based upon what you believe is the unfair treatment that you received as part of the selection process. And we'll get into some of that a little bit. You do have certain areas which sort of don't fall into one box or another, and the one that's most common here is if you're challenging your elimination from the competitive range, if you're talking about a FAR Part 15 opportunity or an opportunity that's been issued as part of a contract by negotiation selection process. So in a situation like that, if you've been removed from the competitive range, you can protest that, and that wouldn't really be a challenge to the solicitation itself, and there's been no award, but you can nonetheless challenge the fact that the agency has eliminated you from competition. But yeah, these are your 2 basic types of protests. We can advance the slide. Okay. So let's talk a little bit about deadlines. I started the discussion today indicating that deadlines are important as it relates to agency level and protests and GAO protests. 10 days is really important. You need to understand that your ability to protest is going to be dependent, at least in part, on your ability to file that protest timely. With respect to agency level protests, you need to file within 10 days of when you knew or should have known of the grounds of the protest. Generally speaking, on a post-award basis, what that's going to mean is 10 days from the date that you received your notification that you were not selected, depending upon what type of an opportunity it is, and we'll get into debriefings a little bit momentarily. The triggering event could be that date, or it could be the debriefing date. Again, it depends what type of an opportunity it is, and whether or not there is a requirement to provide you with a debriefing if you find yourself in that sort of a situation. We'll get into that in a little bit. On a pre-award basis at the agency level, which is the same as it is before the GAO, or even the Court of Federal Claims for that matter, it's before the due date for bids or proposals. At the GAO, you have your same 10-day period as you have at the agency level, and it's 10 days of when you knew or should have known. Again, same as agency level. We're going to talk about sickness days momentarily, and they are important considerations and timing is important relative to that as well. But 10 days is the most important thing to keep in mind if you're interested in either protesting at the agency level or at the GAO. So keep that in mind. Court of Federal Claims, you don't have a set time period within which you have to lodge a protest. It has to be within a reasonable time. Sometimes if a client comes to me and they're beyond the 10-day parameters that would either allow them to go to the agency or the GAO, you're forced to go to the Court of Federal Claims, but you can't wait too long. If you wait too long, it could become problematic for you. And unlike a situation where if you went to the GAO and you received an automatic sick stay, which again we'll cover, you don't have that at the Court of Federal Claims. When you go to the Court of Federal Claims, you're asking for injunctive relief, and there's nothing automatic about getting that. So it's something to keep in mind in terms of timing and when you need to do things. Your substantive arguments can be the best substantive arguments in the world, but if you don't lodge them timely, they'll never be heard. Okay, if we can advance the slide. Okay, CICA, Competition and Contracting Act Stay of Performance. Folks will, generally speaking, go to the GAO in large part because if they file timely, there is a very high likelihood that the status quo will be maintained and nothing will happen until the substantive aspects of the protest are decided. That's why the GAO is very popular, at least in part, and it's a very important aspect to the protest process. So in terms of timing, generally speaking, it's you see here post-award, the agency has to suspend performance if the protest was filed within 10 days of award. Okay, there's your 10 days, or within 5 days of a required debriefing, whichever is later. So, and that's important. It's a little bit different than the time parameters that we talked about in the last slide. What the statute specifically, what the regulation specifically states is that it's within 5 days after a debriefing date offered to an unsuccessful offeror for any debriefing that is requested, when requested, and is required. So it has to be both requested, has to be requested in writing, and it has to be required. A required debriefing, generally speaking, means that the opportunity has been issued under FAR Part 15. You'll see a lot of solicitations that are issued which offer debriefings, but debriefings have to be required to be considered or to be considered as part of the timing parameters associated with obtaining a sick stay. So if you're offering to perform on an opportunity, understand how that opportunity is in fact being offered. Is it a FAR Part 15 solicitation where a debriefing is required, or is it something else? If it's something else, you got to dig down deeper and assure yourself that that debriefing is required by regulation, or you could find yourself protesting, if that's what you feel you must do, too late, right? So you have to make sure that you understand what you're submitting an offer for and what it means to the extent that you wish to protest. There are situations where, despite the fact that you file timely, the agency can override, or at least attempt to override, a stay of award and then performance. And in the times that we're operating in right now, it's important to understand what that, what the circumstances might be in terms of when that might occur. Generally speaking, an override can occur if the agency demonstrates urgent and compelling circumstances. In these times that we're operating in now, you can begin to imagine what those urgent and compelling circumstances might be. We used to not see attempts to override all that much. I didn't see a lot of them early on in my practice. I began to see more of them as time progressed. After 9/11, after 2008, 2009, I've seen instances of them. Doesn't happen a lot. I suspect that we may see some of that moving forward, assuming that the state of affairs continues as it does, and the federal government makes every attempt to press forward with procurements, pushing out solicitations, making awards, and moving forward with its business. You may see much more of this attempt at override as we move forward, so it's something to keep in mind. Okay, if we can advance the slide. Okay, let's talk about intervening a little bit. So if your award is protested, so if you've received notification from an agency that you are in fact the awardee, and a competitor makes the decision to protest that award, you do have the ability most of the time to intervene, and I always encourage my clients to do so when they find themselves in that situation. It gives you the ability to work with the agency for purposes of defending your award and the reasonableness of the actions taken by the agency to issue that award to you. Most of the time, you'll be working directly with agency folks, depending upon the agency and what type of a contract it is, and the types of allegations that are made in the protest. You may end up having more contact with agency personnel than other times. It's going to be entirely fact specific. At the agency level, if you are dealing with that sort of a protest, you might be allowed to intervene. Doesn't happen a whole lot, but it's possible. It's certainly not harmful to ask. It's never a problem asking. It's just rare that intervention would be permitted in a situation like that, and primarily it's because of some of the quicker turnaround associated with agency level protests, which we'll get into in a few minutes. Okay, if we can advance the slide. Okay, and I was just alluding to this just a moment ago. So if you go to the agency, I don't go to the agency very much. I've only done it on a handful of occasions for clients over the years. Why is that? Generally speaking, it's because the person that you are complaining to, if you are lodging the protest, is the contracting officer, a source selection authority person who was in whole or in part responsible for making the award to begin with. It makes it a very difficult argument. It's much less likely that that person will overturn his or her decision as part of the award process. So I don't generally go there. I will if there's something very obvious that was missed as part of the evaluation of a client's proposal. For example, if the source selection authority, if the contracting officer determined that resumes for key personnel were not provided, but in fact they were, and you can point to that as part of what was submitted and identify, well, yeah, they were in, it was, if you take a look at page 27 through 35 of the proposal, you'll see the resumes, you just must have overlooked it, that sort of thing. If it's something obvious, then that's a potential time where you might want to go to the agency and allow the agency to take whatever corrective action it deems appropriate. Otherwise, it's difficult to prevail at the agency level. It is a quicker turnaround time, and it's very informal. You file generally a letter with the agency setting forth the bases for the protest, and they're supposed to provide a well-reasoned decision within 35 days or so of the protest being lodged. You see here on the slide the type of relief that you could potentially expect as a result of lodging an agency protest. Correction of a solicitation deficiency if it's pre-award, post-award, a reevaluation of proposals, or a new best value determination, depending upon what type of a solicitation we're talking about. Okay, if we can advance the slide. You go to the GAO, this is by far the most popular place to bring a protest. You'll see that the filing cost there is $350 to file. In order to file and not have your protest subject to a motion to dismiss, you have to be an actual or a prospective bidder with direct economic interest in the award. We talked about that as an interested party earlier. Generally speaking, what that's going to mean most of the time is that you have a reasonable chance of receiving award if the protest is sustained. We're talking about post-award here, obviously. The one thing that you have to keep in mind is that the GAO does in fact give great deference to the agency, and what we mean by that, it's the easiest way to explain it is by providing somewhat of an example. So if you're going to attempt to challenge a subjective decision made by an agency, for example, if it's a FAR Part 15 selection process, if you feel that you should have received an excellent as opposed to a very good for one of the particular evaluation factors, that's going to be difficult, right? That's tough. And generally speaking, the GAO will afford great discretion to the agency in that regard. But if your argument's a little bit different, it's more legally based and spun a little bit differently. For example, if you take the position that the agency applied an unstated some sort of an unstated selection criteria that should not have factored at all, or certainly factored as heavily based upon the information received, it appears that it did, then that might be that's a little bit different, and that's a better way to challenge what an agency has done as opposed to the first example that I provided. So that's something that you certainly have to be cognizant of as you go down the protest road with the GAO. There is likely going to be a protective order put in place, which clients always love, right? So once the protective order is in place to prevent the dispersal of proprietary source selection information and otherwise, so information is proprietary to a company that submitted a proposal, and source selection information that would pertain to that selection process. Once that's in place, the ability of counsel and client to discuss the merits of a protest is difficult, because as the attorney, I can see it, but I can only tell my client so much about what I'm seeing, and you have to be careful and be cognizant of that protective order as counsel, which can be frustrating to a client who's going through the process, but that's how the process works. Hearings are possible, but they almost never happen. Everything is basically done through documentation. Okay, if we can advance the slide. as part of the process, an agency can take corrective action at any time, and that's always what I consider to be a win for a client. So if the agency sees something in the protest that's lodged that it feels is meritorious, that they made a mistake, they can go back and take correction at any point in time. If the corrective action is not taken, the GAO can either deny or dismiss a protest based upon the arguments that are made. If it sustains a protest, so it agrees with the arguments made by the protesting party, then it makes recommendations to the agency to perform certain functions to fix whatever the errors are. And that's sort of how the process works. If we can advance the slide. Okay, we just actually covered this one. So why don't we advance to the next slide? Yeah, okay, I want to talk about Court of Federal Claims real quick. So as we wrap up here, Court of Federal Claims is a little bit different, as I stated at the beginning. When you're at the Court of Federal Claims, it's a court proceeding. So you have a judge assigned, and you have hearings, and you file pleadings like you do in what would be an injunctive proceeding in a normal district court action, or state court actions, or as it relates to injunctive relief, are very much, they operate the same as well. And you're going to have much more hand-holding than you have either at the agency level or at the GAO. You're going to be in front of a court. You're going to be making arguments. It's a more expensive process, but there are times when being in front of a judge is better than simply trying to argue things on paper. I used to go to the Court of Federal Claims all the time, and I don't do it quite as much anymore, but I do it where I believe that having a judge, will advance the party's interests, because there'll be much more give and take, and it's very fact specific. So every situation is going to be dependent on what you're dealing with as part of the protest process. If there are very complicated issues of law, for example, you might want to be at the Court of Federal Claims and have a judge make the decision at the end of the day. Sometimes you don't have a choice, as we stated earlier. If you're too late to file either at the agency level or at the GAO, you may be forced to go to the Court of Federal Claims, but it's not a terrible option. I'm still there at least a couple of times a year, and the judges are very good. So advance the slide. And that's it. So I thank everybody for joining us this afternoon. If you have any questions for me, my information is there.
Thank you, Ed, for a great presentation and sharing your time with us. And thanks to everyone who joined us. The recording will be on our website and YouTube channel within the next 24 hours. Please join us this Friday as we cover each part of the FAR, and join us next Wednesday for more hot topics in federal contracting.